Good evening, everybody. My name is Gabriella Manalash, and I'm an immigration attorney here in the United States. For today's topic, we'll be discussing why it's important to create an immigration policy for your organization. But first, let's talk about what an immigration policy is, what the purpose is behind it, and then we'll get to some tips in terms of what to include in that policy. Today's discussion will really be focused on people who are employers, folks who work in human resources for organizations, but we will also be giving a lot of really good tips for those of you who are employees or looking to be employees and particularly wanting green card sponsorship somewhere down the road. So in terms of what an immigration policy is, an immigration policy is a document that clearly defines and lays out the obligations that the employer is willing to undertake for sponsorship. And why it's important to have one, there's a few different reasons. First, because of purposes of clarity. So an immigration policy clarifies things like who in the organization is going to be touching immigration applications in terms of maybe preparing them, and if not preparing them, certainly reviewing them and signing off on them when they are prepared by an immigration attorney. Another thing in terms of clarity that the immigration policy will provide is who is the point of contact if your organization gets audited by the Department of Labor or by the Immigration Service known as USCIS, because that's really important to lay that distinction out too. And then another reason why an immigration policy is important is because it conveys a sense of accuracy in terms of making sure that the data about your company is correct in terms of your federal employer identification number, when your organization was created, how many employees you have, and then also it conveys a sense of fairness to your workforce. And what I mean by that is sometimes there are supervisors in different organizations or different divisions who are known as being more green card friendly. They will sponsor and they will help folks get a green card application in terms of signing off and sponsoring applications, whereas some other divisions and departments are not known as being green card friendly and they won't do that. So an immigration policy really sets the tone for things like how long you expect an employee to work there before you will sponsor them, what types of applications you will sponsor, and that kind of thing. So in terms of the tips that we can provide as to what to actually put in the policy, we have four really major things that should be in all immigration policies. The first thing that should be in your policy is clearly defining what types of non-immigrant temporary work visas your company will sponsor and what types of green card applications your organization will also sponsor. The second thing that should be in the immigration policy is defining expectations. And expectations means how long do you expect an employee to work at your organization? Could be 12 months, it could be 18 months before you will undertake the lengthy and often expensive green card process. Something else that your immigration policy should speak to is who will be paying some of the filing fees. Many of the employment-based immigrant petitions, the green cards, and the non-immigrant petitions, the temporary work visas by law have to be paid for by the employer. But there are certainly some kinds of filing fees like premium processing and some dependent filing fees that do not have to be paid by the employer. And many times an organization, as a gesture of goodwill, will pay those fees. But sometimes, particularly when your organization is small, you don't have the means to pay for those fees. And that's something that you can pass off to the person being sponsored for a green card. And then the last thing that we would put into the policy, or that we would suggest putting into the policy, is what will be the organization's role for those employees who want to file a self-petition. So there are many different ways to get a green card here in the United States. And certainly one of them is through an employment-based green card, but there are also green cards that people could qualify for by filing a self-petition. And what that means is they do not need an employer sponsor. They just think that they meet the merits of being maybe exceptional or extraordinary in their field, and they can file a green card application on their own. However, even with self-petitions, oftentimes what happens is those applicants do end up going to their employer because maybe the employer needs to provide an employment verification letter, or they maybe need to sign off on something confirming that yes, their job is permanent, but it's still subject to the goodwill or the at-will doctrine. So it would be great in your immigration policy to really define the scope of your involvement in these self-petitions too. So in terms of 3 tips that we can offer with regard to exceptions that should be in your immigration policy, we'll talk about those next. So sometimes the question becomes, well, if we have an immigration policy that's supposed to define our obligations, why do we even need to put in exceptions? And the reason for that is twofold. Psychologically, no one likes to follow rules and have rules imposed on them, especially when you're talking talking about something that's so personal in nature, like someone's ability to stay in the United States. So having exceptions really sets the tone for your organization as being a reasonable place of employment. Another reason why you're going to want to list the exceptions is because people will ask for them anyway. And I've had about 18 years of experience drafting these kinds of applications for at least 3 major organizations where I have worked in-house. So I do have quite a bit of experience drafting procedures and policies, and I can kind of share with you some of the things that I have seen. So absolutely, people will ask for exceptions, whether they're in the policy or not. So it's a good idea to lay them out. And in terms of the 3 exceptions that we would include in that policy, they are things like starting the green card process a bit earlier for people if they come to your organization having less than 2 or 3 years of temporary visa status left. The reason you want to start the green card policy early, or the process early for those folks, is because if they don't have a green card filing at a certain point in their temporary status, they're not going to be able to extend their status beyond a certain period. So it is critical for those folks who only have 2 or 3 years left of temporary visas to get their green card petition going right away. Another exception that you're going to want to make is for employees who have children who are about to age out of the green card process. And what I mean by that is under immigration law, there's something called the Child Status Protection Act. And what that basically means is that if a child turns a certain age, and it's usually past their teens, they will no longer be able to qualify to get a green card with their parents. They can actually age out of the process. So if you know that an employee has teenagers who are towards college age, about to graduate from high school, it is critical to start the process for them earlier. The third exception that we would put into the immigration policy is for mission critical hires. And what I mean by that is particularly when you're dealing with government contracts or government projects, there are some projects that specify who can work on them and who can see data related to them. And many of them do not allow folks to be on that project unless they're at least U.S. permanent residents or U.S. citizens. So if you have someone in the pipeline that you know will be working on those critical projects, it really is important to start the green card process for them right away. In terms of a tip for an employee, you may be asking yourself, how do I know if an employer has an immigration policy? Even before you start working for them, when you're in the recruitment period, make sure to reach out to your recruiter and ask them for a copy of the policy if you can't find it yourself. Oftentimes, if an immigration policy exists, it will be located wherever the rest of the human resources policies are, but sometimes it may be housed in the general counsel's office, and that policy would not be visible just by going online and looking for it. So you are going to want to ask. Another tip for the employee or the prospective employee, because I've heard this many times, is often when you are interviewing someone who is your potential supervisor, you'll ask them about the green card process. They'll tell you, oh, absolutely, we'll sponsor it right away. Maybe not knowing or not realizing that HR has an immigration policy and they don't really have the authority to make that decision in some cases, or the policy really does lay out how long you have to work there. So I've heard people starting work somewhere and then coming within 2 weeks and asking to start the green card process and saying to HR that their supervisor told them that they could start right away, when the immigration policy says you actually have to work there for 12 or 18 months. So make sure that if someone does give you a verbal confirmation that they can begin the process for you, that number one, they have the authority to do it, and number two, that you get it in writing. So at least that you can show someone maybe that this was put into your offer letter and you've negotiated it before you accepted the job. So I hope these things have been very helpful to you. Again, we've defined what an immigration policy is, what the purpose of an immigration policy is, and we've given you 4 tips on what should be in the immigration policy and 3 exceptions that should be in your immigration policy. Thank you for your time. Again, my name is Gabriella Manilash, and I look forward to speaking with you next time.